I'm often asked by students as exams approach, what areas of the course don't I need to bother with? Well, of course, the strict answer to that is all of it that you're told is examinable, and therefore you need to cover it. But I know people will look through, they look at past exam questions, and they'll take a reasoned guess at what subjects are most likely to come up. Well, if you do that kind of research, you will see that judicial review comes up all the time. In two forms. One, the constitutional issues of it, separation of powers, parliamentary sovereignty, and so on, in the additional role that the judges have taken on in the latter part of the 20th century. So you can look at it from a constitutional aspect. But one thing that is the most frequent way this appears is a problem question inviting you to decide whether judicial review might be granted. And I want to introduce two key concepts. One is I'm going to talk about a set of steps that you need to go through. And if you follow those steps in looking at any problem, then you're going to answer that question. It's a very useful steps. I do it as a flow diagram, make it clear, and I will try and send one out. But I want to introduce the idea of the pigeonholes. Key case is the GCHQ case, which has a much longer proper name of the Council of Civil Service Unions and the Minister for the Civil Service. You can see why people prefer to refer to it as the GCHQ case, because it involved the rights of workers at GCHQ to be members of the union. And the case is important from a whole set of reasons. It's important about the susceptibility of the use of the royal prerogative to judicial review, which was in dispute up to that point. So lots on the royal prerogative in that case. But for judicial review itself, Diplock gives three of the grounds for judicial review. There is a fourth one that you can add later, and that's a breach of convention right because of the impact of the Human Rights Act. But under those four headings, irrationality, illegality, procedural impropriety, and breach of human rights, you can put judicial review. And you have to argue when bringing a case that it falls under one of those headings. But you'll see that certain phrases come up time and time again. Unlawful delegation, right to a fair hearing. Look at those labels. You'll see them in the textbook. You'll see them as you read through judgments. And it's getting used to those almost pigeonholes, because that's what a lawyer will do. Somebody will disagree with a decision and say, I want this to be challenged. And the lawyer has to think, well, which label, which pigeonhole does this go under? And I think it'll be a very useful thing for you to do is actually build your own little table with the four main headings as the head of the columns and put some of these frequently used labels down within that. So that's the pigeonhole concept that I think you may find useful. But how do you approach a problem question on judicial review? The first question to ask is the body that you want to bring the action against susceptible to judicial review? In the early days, this was quite straightforward. Was it a public body or not? But of course, as time has gone on, there's been a recognition that private bodies may actually be carrying out public functions. So, using the case law, and this is an area where case law is very important, you've got to answer that question. Is the particular body in the problem question one, when exercising that power, susceptible to judicial review? The second issue is, does the person who wants to bring the claim, do they have standing? Again, you'll see in the manuals and you'll see in the case law what governs standing. Thirdly, are the time limits. Very strict. Make sure that you know what they are, and again, it's usually part of a problem question where you've got to advise as to whether the time limits have been breached, whether you're out of time. Ouster clauses can be an issue. Now, the courts don't like full ouster clauses. You will, and I hope you will look at this case, the Anisminnick case, where the judges were faced by a provision in an Act of Parliament which said that the courts cannot consider disputes involving this piece of legislation. What the courts did, it was a very clever piece of footwork, was they said, right, the government, when it used this power, says that it was using it under the authority of the Act. Well, the Act doesn't authorise illegal use. It just can't happen. You can only use powers legally, or you're not basing your authority, because there can be no authority in the original Act. So they said, when the Secretary of State did what he did, he was acting not under the Act, in which case we wouldn't have been able to look at it, but he's using powers outside the Act. We're no restricted, and the way that he's used that power isn't accepted. We'll review it, and they got over the ouster clause that way. More likely in a problem question you'll find a partial ouster clause. The time limits are much shorter than judicial review time limits and that sort of thing. Again, from the case law you'll see how the courts approach these. A reasonable shorter time may be fine, but when it becomes unreasonable, unattainable, then they're going to say no. So fourth was, is there an ouster clause? Would the courts apply it? Fifth, the important one, the grounds of challenge. There's rarely just a single ground of challenge, and this is where you demonstrate the width of your knowledge of the different labels, the pigeonholes that have been accepted by the courts. And as I say, really the only way to do this is by looking at judicial review cases and seeing what labels have been used. You'll see them reflected again in your textbook and your manual. And don't forget, and this is often forgotten in problem questions, is what remedy would be most appropriate. So judicial review questions, they can all go through this logical series of steps, and if you fully answer each of those steps, then you're going to pass your TMA and your exam. Thank you for listening.